Good morning. Today I want to give you what I would call probably a legal lesson. Let me give you some examples. A lot of the stuff you might not understand that's on my site. One of the things is the ineffective assistance of counsel, and Strickland versus Washington, there's a two-pronged test to overcome. Basically what it leads down to and what it says is, if a lawyer looks at a piece of evidence, doesn't matter if it's a videotape showing that you're completely innocent, it doesn't matter if it's DNA showing you're innocent, whatever the reason. If he strategically chooses not to use this evidence as his professional opinion, you have nothing coming, no matter what the evidence says. It's one of the things they're trying to fall back on. Another thing that I'd like to address with you. Good example will be my insufficient evidence issue that I posted on this site. I mean, this is proof positive, right? This is basically like saying, I solved this murder based on this DNA, blah, 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 right? Here's the problem. The problem is the United States Supreme Court will never hear this issue. The reason why is because this is the way that the courts work. With your 3 federal courts, you have your local district court. I chose the Eastern District of Michigan over here in Detroit. There's a couple of them, basically like your courthouse for Gaylord, Wyandotte, for Wayne County, whatever. It's just like a local courthouse, okay? Now, when they deny an issue, you have to request a certificate of appealability in order for the 6th Circuit U.S. Court of Appeals to have jurisdiction to hear this issue. They did not do that on all my issues. The only issues the 6th Circuit would hear are the ones that I had certificate of appealabilities on. They do not have jurisdiction to hear none other than that. The same standard applies for them. So basically, I did not get a certificate of appealability from the 6th Circuit or the Federal District Court, which means the United States Supreme Court will never, ever hear this issue. It's being barred. It's procedurally barred. And it's under the bar doctrine based on the fact that jurisdiction has to come from the previous judge who denied you telling the higher-up judge that you have a valid issue that should be looked at. So not only do you get to take my issue away from me and deny me, you get to choose whether or not you can have somebody else who's in a higher position look at it even. That's how the law works. And as far as suing your lawyers go, for legal malpractice, you got a 2-year statute of limitations. If you do not file within that 2 years with a request to stay in abeyance and put it in abeyance, while you go through your criminal appeal process, then it gets dismissed under a collateral estoppel, which means that you can never file it again. It's dismissed with prejudice, even if later on another court overturns your conviction for ineffective assistance of counsel based on the fact that your lawyer did basically what mine did. He showed me a witness list, told me these people were going to be there and all this stuff, and none of them were there. He had all the evidence that he told me he was going to use but never used. Well, come time for federal court, now that he's the Assistant Attorney General, they're prosecuting domestic violence cases out of the same county that put me away. He can't recall anything. I can't recall this. I can't recall that. They're falling back on he interviewed witnesses and chose not to use them for strategic professional reasons. He didn't interview none of these witnesses. Not one single one. I've talked to every single witness that was ever supposed to be there. Not one of them got a phone call from him. Not one of them seen him. Not one of them talked to him. Not one of them was even asked their side of the story. All their statements they gave police was prior to finding out that people were saying after throwing the ground, put guns to their heads and all these misfires and blah, 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 which is BS. Another good example would be I ran into a girl at Walmart in Gaylord. Her name is Megan Kimbler. And I told her about the Shannon Brower girl saying that she came out of her house, walked in between these 2 trailers and seen me pointing this gun at this guy, right? She got mad. She got mad because she said this girl never left her fucking house. Nope. Her boyfriend wouldn't let her out the door when all this stuff was going on. He had the door barricaded and blocked. Wouldn't let anybody out of their house. But she's seen this. They used her testimony to bind me over for assault with intent to murder by putting words into her mouth. She heard this trigger being pulled, even though she says it's a rock, a bottle, anything. Read the insufficient evidence argument, because no judge ever will again. How deep does the rabbit hole really go?